Good afternoon and welcome. My name is Mary Ann Monteleone, Vice President of Professional Development for the Long Island Board of Realtors. Today's webinar is a broker-only webinar, which is being offered in a series of broker communications that LIBOR is committed to bringing you. Today's webinar is all about risk management tips for 2024. Well, you'll learn today about several important topics, including the upcoming New York property disclosure law, antitrust, advertising, cybercrime, artificial intelligence, vacant land scams, and of course, fair housing. Today's presenter is LIBOR's General Counsel, Patrick Fife, and we're happy to have him here with us. So I turn it over to Patrick.
Great. Thank you, Mary Ann, and very happy to be here. And before I begin, just want to let everybody know that the slides for today, I will make them available to anybody that came. If you have to leave for some reason, we are going to make the slides available basically to anybody. I also just wanted to let everybody know we do have a broker brief that goes out every month, which kind of goes over a lot of risk management tips. It includes a broker resource deck. So if you haven't signed up and you're not getting that, please go to our website. You can reach out to our communications team if you need help on how to get that. But we try to deliver to you as much throughout the year to help you with risk management issues. So with that, I thought, I kind of went back and forth about where do I start today. I was going to say, well, maybe I should start with, a more interesting topic like artificial intelligence. Should I start with the property condition disclosure statement changes, updates on the antitrust lawsuits? And I kind of made a decision this morning. I said, you know what, I think where we need to start is the broker's duty of supervision, because it all comes back to that. The New York State law it specifies what your duty of supervision is with respect to anybody that works under your license. And it's a pretty heavy duty. This is right from the regulation. It says shall consist of regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence by the broker with respect to the real estate brokerage business conducted by the broker and all matters relating thereto. And that duty now extends to office managers. The law was changed about 1.5 years ago. So if you're a broker, you're an office manager, you have a duty of supervision. So your agents may make mistakes. It's going to happen. DOS may investigate them. And then DOS may look at you and say, hey, broker, office manager, what kind of supervision have you exercised over this agent? So what can you point to? What education have you offered? What periodic spot checking do you do? What's your process? What's your supervision plan? So when I take you through a couple of these issues, think about it, and I'm going to kind of give you some pointers and some guidance on what is your supervision plan with respect to these items, and what can you do. And I mentioned that broker resource deck. Hey, that's something that you can do to help supervise. Go through it at your sales meetings. Distribute some of the items that are in there that are educational to let your agents know this is how you have to be doing things. You can't be there all the time. You can't, be on top of everything. Again, many of you employ independent contractors, and understood that you're not on top of every single little thing, but you need to be able to demonstrate that you are engaged with regular, frequent, and consistent personal guidance, instruction, oversight, and superintendence. I forgot to mention two things. Juana just asked about, I need that monthly resource info. Well, we can get that to you if you reach out to the communications department. And again, there's a sign up on our website under broker risk management. It's under the legal page where you can sign up for the monthly emails that we send that out. But we will make sure that we get that to you. So that was one. Two, I also wanted to let you know that all of the links in this slide presentation, once you get it, they're all going to be active. So if I've put a lot of resources in here for you to look at afterwards or distribute to your office, they'll all be links. So you'll just need to click on the links to get all of the additional information that I provided. So I want to now turn to artificial intelligence. I mentioned that as one of the topics that I wanted to cover today. And I just want to give you some tips for limiting the risks associated with using AI in your real estate business. Hopefully you all know what AI is. Hopefully you are using it. I think it's a great tool. I think it is something that you should use in your real estate business. For those of you that don't know what it is, it's basically the simulation of human intelligence by computers. So computers are trained to assist with a variety of tasks. The computers can learn from their mistakes. I think the most common form of AI that many of you probably are familiar with is ChatGPT. It's a program that can produce human-like text conversations with people. But there are tons of other platforms, programs out there that are AI, and they can be used. And there's a lot of courses now that tell you how you can use it to create listing descriptions, property searches, social media posts, marketing, imagery, tons and tons and tons of stuff. And again, I think it's great to use, but I just want to make sure that your office avoids the potential issues that can be associated with its use. And I have a quote here that I thought kind of summed up from a lawyer's standpoint what the risks are. And it's in the dimly lit corridors of justice where the echoes of legal battles reverberate. The advent of artificial intelligence casts a foreboding shadow, painting a legal landscape fraught with peril and intrigue. Thought it was a great quote. I read it yesterday. Anyone want to guess in the chat who said it or where did it come from? Don't see anybody guessing yet. Well, it actually came from ChatGPT. That was yesterday. I asked ChatGPT to generate me a quote, describe the risks of AI in the style of John Grisham. And that's what it came back with. It's pretty incredible what you can do, with AI. It even gave me, titles of books that John Grisham would have authored on the legal risks of AI. They call the liability abyss. Whispers of Discrimination, The Phantom of Privacy. So it's just incredible what you can do with it. But there are risks. And the four ones that I want to just cover, the first is inaccurate information. ChatGPT is not fully up to date. And no AI is perfect. If AI can make things up, it can be outdated. ChatGPT, if you use the free version, it's only been trained with data through January of 2022. Even the paid version right now, I just read last night, is only updated through April of 2023. But other programs other than ChatGPT also make mistakes. I've seen demonstrations where agents are using artificial intelligence to enhance or stage rooms. Great, but sometimes it makes mistakes where it actually adds structural elements or takes away structural elements of that room, which can be a problem because now you're misrepresenting the actual configuration or structure of that room, which could get you in trouble not only under the advertising regulations, but under the code of ethics too, in terms of concealment, exaggeration, not being honest and truthful in your advertising. Another issue, there are bias and fair housing concerns. The data that these programs are trained on is data that's been generated by humans over a long period of time. There are biases that exist within that information, and those biases can come out in the output from some of these programs. So, I know one recommendation is if you're going to use something like ChatGPT or an AI program, you can train it and say, let's say you're using it to create a listing description or write a blog article on a particular issue. You can say, taking into account fair housing considerations, write me a listing description for this property. So there are ways to try to mitigate it, but you have to make sure that you're aware that those concerns exist and you're reviewing the output. Privacy concerns, what you put in to these programs is not private. So, you need to avoid putting in confidential information. If you're using an AI program to generate email responses or text responses to clients, make sure that your clients aren't putting confidential information into those particular communications without knowledge that that information may not be confidential. And lastly, copyright is the fourth concern when it comes to AI. It's a mess out there in the law. It's completely undecided who owns the copyright to information that comes out of these programs. Is it the person that put the prompt in? Is it the company that generated the AI platform? I mentioned John Grisham, and there was a reason not only does he write, law novels, but he actually has sued one of the AI platforms, claiming that it's basically using his copyright of the information, his books, to create output that, by training these programs using his original copyrighted works, his copyright has been violated. And it's going to be years before the courts make determinations on who owns the copyright, what copyright claims are valid. Right now, I think it's generally understood that it's safe to use information that you get out of some of these AI platforms, but no one can guarantee that that's going to be the law. That's how the courts will ultimately settle it. It could take years. As you probably know, our court system moves very slowly, so it's years behind the technology that may be in place today. So, what are my tips to limit your risk when you're using AI? Well, review everything for accuracy, suitability, double check everything for fair housing concerns, the language being used. Don't use it as the end all be all. I think it's best to use AI for brainstorming, use it as a starting point, not the entire process. I would also say if you're going to use it for things like listing descriptions, those need to be thoroughly reviewed by somebody with a real estate license. You can't trust these programs to do work that a licensee is obligated to do. Same thing, never, ever, ever use AI to draft contracts, modify standard forms, or provide legal advice. I've messed around with ChatGPT to see what would happen if I gave it questions, legal questions. I've noticed that you now get responses that include a disclaimer saying that it can't provide legal advice and you should follow up with an attorney. Take that advice to heart. Do not use AI to modify forms. There was an attorney this past summer who tried to use AI and ChatGPT to write a brief. And he was ultimately embarrassed because the other side in the litigation read that brief and found out that ChatGPT had cited to cases that didn't exist, cases that were made up. It couldn't distinguish between what a real court case was and what reports of kind of hypothetical court cases were. He was ultimately sanctioned by the court. So certainly attorneys shouldn't be using it. You should not either to do any kind of legal work. And I would say ultimately, look, consider having some kind of AI acceptable use policy in your office when it comes to the use of AI, especially in advertising. I think you need to educate people who are in your office on the risks and on how they should be using AI. I'm going to talk a little bit later about advertising. That duty of supervision I talked about, it explicitly extends to advertising. So you have a duty to supervise all advertising, and that would include any of your licensees that are advertising using AI. All these resources, again, this presentation will be made available to you. All these are click-throughs that you can get more information. You know, I'm just here at this point. I want to kind of give you an overview of the topic, what to look out for, but a lot more detail in these resources that you'll have access to. Next thing I just want to cover is cybersecurity. And I know you probably have heard a lot of presentations on cybersecurity, read articles. I just want to hit home that it is a real threat in our business, in real estate. It's a huge threat. I just sat through a program yesterday by the Suffolk County Bar Association, talking about, you know, all the attorneys, the real estate attorneys, who have been subject to cybercrime. It has, you know, these statistics are staggering. New York State cybercrime has risen 53% since 2016, and that's only through 2022. The numbers for 2023 haven't been calculated yet. And we are a prime target in New York. The third highest number of ransomware attacks in the country occurred here in New York in 2022. You probably heard Suffolk County. They're still, I think they are fully back online now, but it took them upwards of a year to recover from the cyber attack they were hit with in 2023. Rapatoni, who hosts many of the nation's the data for most of the MLSs in the country, was hit with a ransomware attack in 2023. And although those are big outfits, I want to emphasize that real estate offices of any size are targets. And I think that small offices are just as much of a target, if not a bigger target, than larger offices. And you might scratch your head and say, why? Well, I think scammers, fraudsters, whatever you want to call them, they think that smaller offices probably don't have the protocols in place to protect themselves. But they also realize small offices, you know, you can be an office with one broker or a broker and one agent. Doesn't mean that you're not handling a multi-million-dollar deal. Same thing with law offices. I've heard of a lot of law offices, and in particular, small law offices who have been the victims of cybercrime. And again, I think that these hackers, fraudsters, whatever you're calling them, they know that those small offices may not be equipped to deal with that situation. And you should be able to. How do these things happen? You know, what are the types of crimes to look out for? The first one's called, probably heard this, phishing, smishing. I've never heard vishing. This was, but they're all a form of different types of ways where the fraudsters are going to try to send you fake emails, unsolicited emails, text messages, whatever it is, try to get you to respond, put in your password. You know, the simple ones are these fake Amazon emails where they want you to put in all of your information. But they certainly then can rise to the level of bank information, other things that they're trying to get. The big one, and I think in our industry, certainly wire fraud. The fraudsters are trying to compromise email accounts to basically get a foothold into somebody's email involved in a transaction. And I know that you're not the ones typically handling the money, right? The closing attorneys are you know, usually the ones transferring the wire instructions. But a lot of instances that I've heard about of wire fraud have been someone else in the loop, and you may be copied on emails back and forth, right, with the attorney. So if a fraudster is able to hack into your email and they're sitting there watching, that's all they're doing. They're watching the emails back and forth. And then the day before, the day of the closing, they then impersonate an email from someone else, one of the other attorneys, because they know who the attorneys are. They're watching, they're sitting. And then they send an email to the buyer's attorney from someone who looks like the seller's attorney, and say, "Oh yeah, we're changing the wire instructions. Seller wants to split the money, half's going to a different, whatever it might be." And they got in using, because they hacked into your email account. There's liability, potential liability there for you. So although you're not the one transferring the money, if you're the kind of entry point, you could have liability. So you really need to make sure that, you know, you have protocols, and I'll talk about those in place to prevent you from being the point of entry to a wire fraud. Ransomware, that's what happened in Suffolk County. Suffolk, they had cyber criminals who put malicious software that basically locked the county systems and demanded a ransom. Same thing with Rapatoni. But that also, it's not just big outfits, it's small outfits that get hit. The impacts, the top three or top two, I think are obvious, data loss, financial loss, but there's also the risk of, I think, damage to your reputation and loss of clients. I've heard from other attorneys who know other attorneys who have been the victims of cybersecurity breaches, and in most cases, some cases, they were able to ultimately prevent a financial loss, but they had a loss of confidence from their client to say, hey, you basically subject me and I almost lost X number of dollars due to this, this fraud. I don't trust you anymore. So that's, kind of the loss that people don't consider. But damage to reputation, loss of clients can be just as big as the financial loss and data loss and loss of productivity. So how can you prevent this? On the left side are what I say the things that are really the preventers that will stop it before it can happen. You need to train and educate your entire office. And I include anybody. It's not just your licensees. Your office assistants, they need to have best practices when it comes to everything. And the second thing is that strong password policies. Update your passwords, use a password protection program. Generate very secure passwords. Use multi-factor authentication. I know sometimes it's a pain, and that means it's the system where you have to get something and you can't see, here's my phone, where you get that text message with the code and you have to enter the code before you can get into a particular program. It's an extra layer of security, so that if somebody does inadvertently put a password into something, they have to also get that code. And as long as you have that, it can be a huge preventer. And it's very simple to add to many different things. Updating your software, investing in network security, regular security testing. Considering bringing an expert in, whether it's once every year, 2 years, to test your systems, see if you have vulnerabilities. On the right side are the things that you really can help you in the event there is a loss. Have an incident response plan. That means the minute that there's a problem, you know who to contact. You don't have to scramble. And it goes to having it printed in paper. You get hit with a ransomware attack where you're locked out of your computers. You got to go back to the old way of doing things. You may have to pick up the phone and call someone and not know where their number is because all of your contacts, your computer is locked. So have that incident response plan. Have your data backed up so that you have a secondary way to access it. And lastly, just consider cybersecurity insurance. Have everything ready there just in the event you are, hit with something and you're ready to respond. Tons of resources on this. Got everything, even including form data security plans that NAR, the National Association of Realtors, put together. Again, all of this will be in the slide deck and you can click through for further information. The last scam that I want to talk about today, and then we're going to move on to some other stuff, is tips for avoiding vacant land sale scams. They are prevalent at a national level. They're prevalent at a local level. I've talked to some of you brokers out there. I've talked to attorneys locally who have been involved in transactions that it ultimately was determined the person who was claiming to be the seller was not the seller, but was actually a scammer. There was a Long Island resident who last summer, his family-owned property in Connecticut, went to go pay a visit. It was vacant property. And he found a house, brand new house, about $1.5 million house sitting there on the property. It turned out a scammer had impersonated him and sold the lot to someone else. The transaction actually went through. It is possible that these scammers are able to effectuate a transaction. And what do? Well, they're first is they're taking advantage of the situation that we're in. We've got very low inventory, right? So they're hoping that all of you are going to rush into a listing. You get that phone call from somebody saying, I've got vacant land and I'm looking to sell it. I've heard that you're the person. I know you've sold some properties in the area. I'm ready to move quickly. I'm looking to sell it quickly. There's been a death in the family. We need money, whatever it is. They give you some facts and they sound legit. And they sound like they're ready to move and they respond to every text message, phone call, and they're going to get you that listing agreement signed right away. And they seem to know everything about the property, at least what's publicly available. And they use public records to find all that out. That's what they're trying to do. They're trying to get you to think that they're the owner, sign up that listing agreement. They get in contact with the attorney you recommend, and they're off to the races, hoping that everybody just goes forward and gets this deal done. I actually read a couple weeks ago a Secret Service representative in the New York field office. So this is local. Told it was Yahoo Finance. He said that scams are becoming a bigger issue and they frequently take calls on the matter. I've talked to attorneys here on Long Island, Suffolk County, that have been involved in situations where they got listings from a broker. They started on the transaction only to find out that after verifying things that the person they were dealing with was not, in fact, the property owner. So what are the red flags? Again, I mentioned urgency. They want to sell quickly, below market value. It's quickly. They're looking to move quickly. They're looking to, and they will communicate with you quickly. They prefer to text. They prefer to email. They don't really want to get on the phone beyond that initial phone call. Oftentimes they claim to be from out of the state, out of the country. They ask about remote notarization, closing using power of attorney. They're looking to move quick. So what do you do? How do you avoid it? You don't want to get to this situation to rely on the attorney to necessarily like ferret this out. And I'll give you the reason why. An example that somebody gave me, and it was a real situation where the attorney did foil the deal. He represented the person who was supposed to be the seller. Ultimately had some questions that he couldn't get the answers to, started kind of looking a little further, digging. And turned out he found a picture of the seller on the internet. And he's like, I don't think this is the person I'm dealing with. Reached out to that person, got their contact information. And it was right. He was not dealing with the seller. Deal never went forward. But the buyer in that case, not his client, he was representing the supposed seller. The buyer had spent about $10,000 on surveys, engineering costs, looking to design a new house to build on this vacant lot. Was furious. Furious at the listing broker to say, how could you take this listing without confirming that you're dealing with the real owner of the property? So what do? Demand an in-person meeting. I mean, I think in almost any instance, in any case, you really want to meet with a seller in person. There may be reasons that they can't. I mean, in this situation, they're going to say, hey, I'm out of state, I'm out of country. Then say, you know what, get on a Zoom meeting right now. Use the technology we have. Get face-to-face. More often than not, someone who's a scammer will not do that. Ask for multiple forms of identification. Do what I said. Just do your homework. Search the internet. Just confirm the details of the seller, verify the owner's phone number and email. If you find that the person who's in public records has a different phone number, reach out to that person. And if you do suspect you're involved in a scam or you do confirm it, immediately contact law enforcement, file a complaint, and quickly remove that listing from the MLS and all advertisements. And I'm spending some time here because this is real. It is prevalent in Suffolk County. Again, I've talked to so many of you. I've gotten reports. So just slow down. When you get a call about vacant land, slow down, do your due diligence, and confirm that you are really dealing with the owner of the property. A lot of educational resources on this. NAR, again, it's a national issue too. They put out a one sheet that you can circulate within your office. So the links to that are there. We've put out some legal tips, so more information on this too that you can circulate to your office. Mary Ann mentioned New York State Property Condition Disclosure Act. There are some changes coming to the property condition disclosure statement, changes coming to the process. The property condition disclosure statement is being changed to include a number of flood-related questions. And there's also the elimination of the $500 opt-out credit. This all goes into effect March 20th. It's not in effect yet. For those of you that aren't familiar with the law, so the Property Condition Disclosure Act came about in 2002. I think that was the date of the law. I think it went into effect 2002 also. And it says that sellers of residential real property, there's a number of exclusions: condos, co-ops, estates, bank-owned properties, where the seller wouldn't have knowledge of the history of the property. But residential real property with those exclusions containing up to 4 dwelling units, they have to provide a property condition disclosure to prospective purchasers prior to the buyer executing a contract of sale, having a fully executed contract of sale that details known defects. And there's a 6-page document with 48 questions. There'll be more questions on the new document, and the seller has to answer those. Well, the law, when it was passed, had a provision that said sellers can opt out. If a seller did not want to provide that form, they could provide the buyer a $500 credit at closing prior to the passage of title, and they wouldn't have to provide the form. So I think the practice here, downstate, Long Island, New York City, has been that for the most part, sellers gave the credit. I used to handle real estate transactions before I came here to LIBOR, and that was typically the practice. I don't really recall any deals where the seller didn't provide the credit. Well, that is being eliminated. The seller will no longer be able to opt out and provide that credit. And there's also going to be a whole bunch of new questions related to flooding on the form. And one of those questions has to do with whether the property's experienced any damage or water penetration seepage due to any kind of natural flood event, including heavy rainfall, coastal storm surge, tidal inundation, river overflow. Same question that's on the that has to now be, or information that has to be disclosed in connection with a lease. So now that also has to be disclosed in connection with a purchase. So this is really going to make the property condition disclosure statement required on every transaction in New York. So what are we going to do? You got to stay tuned first. The new form is not yet available. The state probably won't have it available until March 20th or just before. So the new form is not out yet. One Key, will be updating the exclusive listing agreement. Right now, it has a statement in there that says that the seller can provide the property condition disclosure statement. I know there's also a disclosure form on Instanet that shows that you've delivered the statement and also explained the requirements under the law. That mentions the $500 credit. That will be changed on or before March 20th. And essentially, the disclosure now will just say that the seller must sign the property condition disclosure statement and deliver it to the buyer prior to contract of sale being signed, and also that the signed copy by both seller and buyer must be attached to the real estate purchase contract. Your obligations and your agent's obligations remain unchanged. That aspect of the law hasn't changed. So the law still says it's your duty, listing broker, you have to provide the statement and just inform the seller of their obligations under the law. And with the buyer, you just have to inform them of their rights and obligations under the law. And as long as you do that, you cannot have any liability for violating the statute. The only change would be that when you provide the form, you're not going to include that information about the $500 credit being available. So best practices, you're going to want to document that you delivered the property condition disclosure statement to your sellers. and that you inform them of their rights and obligations. And again, that's in there's going to be language. There is language now in the listing agreement, the one key listing agreement that explains the obligations. And then you should strongly recommend, whether it's a buyer or a seller, that they discuss ramifications and requirements of the property condition disclosure statement with their attorneys. You should not be completing the form for sellers. You shouldn't really be helping them answer questions. It's based on their knowledge of the property, not yours. And if they've got questions about the ramifications, they're going to need to discuss them with counsel. You should not get away from, again, your obligations, the licensee's obligations, they remain the same. They have not changed. So we're going to put out more information on this before March 20th through LIBOR, so stay tuned. And again, updated forms will be made available soon. But wanted to give everybody a heads up because I know that questions are being asked, but the operative date is March 20th. All right, couple more topics, and we're probably going to go about an hour, maybe a little bit less. I haven't seen any questions in the chat. I don't have the Q&A up, but if there are additional questions or things that come up, we can address them at the end. I want to now talk about tips for moving forward after the Sitzer-Burnett class action verdict, which I think most of you know what I'm talking about. A 30-second explanation for those that don't. There has been antitrust litigation pending for a couple of years in the real estate industry. And specifically NAR, the National Association of Realtors, and 4 corporate brokerage defendants were sued in 2 class action lawsuits, one in Missouri, one in Illinois, back in 2019. The Missouri case was called the Sitzer-Burnett case. And those cases alleged that basically sellers were paying too much commission. The commissions that they paid were too high. That by the process of offering out cooperative compensation to buyers agents, that sellers were paying too much, and that NAR's rules and policies, along with the corporate defendants' practices, was the cause. And they felt that requiring listing brokers to identify offers of compensation, cooperative offers of compensation, artificially inflated the commissions that the sellers paid, and that the sellers were damaged because they paid more commissions than they should have. So the Sitzer-Burnett case was a class action that covered the Kansas City, St. Louis, Columbia, Missouri area. That's the one that went to trial back in October. And after an 11-day trial on Halloween this past year, the jury said, you know what? The defendants are liable. And they're liable for $1.78 billion in damages, which gets trebled under the law, meaning tripled, to $5.3 billion. So that's probably, that what you've heard. NAR has stated it's wrong. The verdict was wrong. It's seeking to reduce the jury's damages. It's seeking to appeal. And it's in the process. It's filed post-trial motions and is in the process of then appealing. You may have also heard there's been many copycat lawsuits filed since. There are currently, I think as of yesterday, I read 19 different cases that on kind of this same issue have been filed. So NAR just announced yesterday it's asked the Judicial Panel on Multi-District Litigation, which is kind of a federal body that oversees litigations of the same type being filed in different parts, class action litigations being filed in different parts of the country. And it's asking all those overlapping cases to be consolidated into a single multi-district litigation in federal court in the Northern District of Illinois. So that's where things stand right now with all these cases. So NAR's arguments and what they continue to argue and what they are going to be arguing is, that sellers are the ones that decide if they offer commissions to buyers agents, that this cooperative compensation rule, it allows for efficiency and transparency. The consumers are better off. Competition actually thrives because of the way the system works. Sellers have the opportunity to sell their home for more, have their home seen by more buyers. Buyers can afford representation. They're not necessarily paying upfront out of pocket to have a representative. So that gives them the accessibility, and especially first time low middle income buyers, the potential to have accessible representation that can be paid at closing. And the other thing is that it's, again, ultimately the sellers. The sellers decide. The sellers, the rule in terms of cooperative compensation doesn't require any specific amount of compensation to be offered. Sellers get to decide what they want to offer. They can offer as little as a penny, a dollar, or even zero. NAR has always said compensation is always negotiable. Seller decides if they are, what they're willing to pay for their broker services and how much they want to offer a broker who brings the buyer to a transaction. So you may be getting questions. Your agents may be getting questions from customers, from clients about, well, what does this mean for me? Well, it doesn't change things for you in a sense that you should be doing what you always should have been doing. And that is, you need to discuss compensation scenarios, arrangements in detail with sellers and buyers up front, and put whatever agreements you have with them in writing. So if you're working with a buyer, it's important to use a buyer representation agreement and explain to the buyer how you're getting paid, what services you are being provided, and who you anticipate is going to pay for those services. So it's, you can't just enter into an agency relationship and expect to get paid. You've probably all taken agency courses. You have to. And I think agents need to be told this, that agency and compensation are not the same thing. That you have to have a separate compensation discussion with your sellers and with your buyers, and go through the process and take the time to go through it. And the process only gets complicated or problematic if you don't do that. So that discussion needs to include, hey, commissions are negotiable in terms of what we or you want to offer out to the buyer side. NAR has confirmed that a seller can even offer zero. It just has to identify what the offer of compensation is. And whatever they offer, there can always be a negotiation. When NAR confirmed this, One Key updated its listing entry system. So you can put in any amount, including zero, in what is being offered to a cooperating broker in the field. But that does not mean zero must be offered. I've seen and heard that question. That doesn't mean zero has to be offered. The decision about what to offer should be between the listing broker in consultation with the seller. They should discuss what compensation they are going to offer to cooperating brokers, what they deem to be appropriate to facilitate a transaction, and then that should be confirmed in writing. So it's crucial, I think, to not only for you as a listing broker, but you have to have this discussion with your agents and explain that they have to walk through this compensation discussion with sellers and with buyers. So we've given you a lot. NAR has given you a lot of resources. NAR has competition.realtor. It's a whole website devoted to articles, key points, infographics that explain the compensation process, things that you can use with sellers, with buyers. We have also, LIBOR has created a brand new buyer representation resources page. Lots of information that you can use to help train people in your office, but also information that you can share with your clients. We've got links to different courses that you can take, that you can recommend agents in your office take. We have an form exclusive buyer representation agreement, articles on how to introduce a buyer representation agreement, the benefits of using one. So there's a lot there that you can share with people in your office to help them better understand the process and make them more comfortable, with it. All right, next topic I'm going to move on to now is real estate advertising and tips for supervising your office's real estate advertising. So I don't know if many people know this, but I went back in the beginning, I talked about the duty of supervision, right? There is also a specific explicit duty of supervision when it comes to advertising. The New York State regulations say that all websites created and maintained by salespersons, associate real estate brokers, teams, they're allowed, but they must be duly authorized by the broker to create and maintain that website. And such websites remain subject to the supervision of the real estate broker. So teams, salespersons, associate brokers, they can advertise, but it has to be with the permission and supervision of the broker. And I will say DOS is hitting offices with fines for advertising violations, and they're not showing much leniency when it comes to that. And because ultimately it's the broker who has to authorize and should be supervising, brokers can be subject to discipline based on their licensees advertising. So what are you supposed to do? Well, you are required to supervise and approve advertising before it goes live. And I think there are salespersons out there that don't necessarily understand that you as the broker have to authorize what they do. So you should be implementing, think about what policies do you have? What guidelines do you have for advertising? What type of spot checking, organized system? Do you have to monitor the activity of salespersons in your office to know that they're doing something wrong? You need to think about and have some kind of process in place when it comes to supervising advertising. Regulations also say that anybody in your office who has their own website, they need a link back to your website, provided you have one. I think now most brokers do have websites, but anybody. So if you have teams that work under you, you have salespersons that have their own websites, they need to have a link back to your website. That is something that is required under the law. So I've got there's 3 links in here on this slide that you should take a look at afterwards. And the bottom 2, I absolutely encourage you to share with everyone in your office. They're right from the Department of State. There's a real estate advertising guidance that they publish, and they have a real estate advertising checklist that kind of goes through what they recommend for every type of advertisement. I'd encourage you to share them within your office and make sure that everyone in your office is following them and knows them. And I see a comment here from Ruth that the DOS just sent the advertising guidelines advisory to every New York State licensee. I wasn't aware of that, but she's absolutely right that I think this is going to be a focus for them. It is absolutely low-hanging fruit, easy fines to collect, and it's easy to detect. It's advertising. What's the purpose of advertising? To get attention, right? You're putting it out there. You want people to see it. Well, DOS is looking too. So the better you are at it and getting it out there, the more likely DOS may see it. So make sure it's being done right, because if your associated licensees are doing it wrong, it ultimately is your responsibility. It's your duty to supervise. And this extends to social media. Facebook and Instagram, they are considered forms of advertising if your licensees are using it to promote real estate activity. So although it may be their page and they may be posting about a ton of other things, their vacations and whatever else they're doing, their kids, grandkids, pets, that's great. But if they're going to promote open houses that are of your listings, again, you're the broker, it's your listing, they're going to promote a new listing that just came out in the office, that page is now advertising. So you need to make sure you can't check every post, you can't check every page. I get it. But do you have a system that you check occasionally? Do you have a system that lets everyone in your office know that they have to make attempts to comply with the advertising regulations on their social media pages if they're advertising? Have you approved them advertising on social media? Do they have your brokerage name, their license type, your either address or office phone number? The basic core things that advertisements need should be on the social media pages if they are going to advertise. And even though they may only have 3,000 Instagram followers and 500 Facebook friends, and they'll say it's a limited group, it's still advertising. Anytime you put things out to the public, meaning any member of the public, it's considered advertising, no matter the reach. So have a system in place. And if you have that system, it's not that hard. I heard somebody complain to me once, how can I look at every post? No, you can't. But you need to have a system that at least lets people in your office know what they have to be on the lookout for, and do occasional spot checks. So I'm going to end with two topics. Tips for my two fair housing topics: avoiding lawful source of income discrimination and disability discrimination. And the reason why is because those are the areas that undercover testing is taking place on. I can just tell you based on what I see and what's reported, that's the focus of most of the undercover testing right now. There's probably undercover testing going on in sales and other areas, but the two areas where the most undercover testing is going on is lawful source of income and disability discrimination, both in rentals. And I think it's twofold. It's easy to test, and there are a lot of violations that are still happening. So I think you need to have a process in place that educates your licensees on how to avoid these things. Encourage them to take classes, provide them the resources we give when it comes to these two protected classes, and just make sure that they understand what their obligations are. So what's lawful source of income? It's a protected class. It's been so in New York State for almost 5 years now, and says that you just can't discriminate against somebody based on where they get their income from. So you can ask someone about their income. You can ask them what the source is, and you can ask for documentation, but you have to treat it all equally. You can't discriminate against somebody, and a housing provider can't discriminate against somebody because of where they got their income. It has nothing to do with the amount of income. It's where the lawful income comes from. It can come from anywhere. That's lawful. And the big area that I think you see most of the claims, the cases are housing choice vouchers, Section 8, and public assistance. I heard a great example the other day. I mean, asking somebody about, well, do you get your income from Section 8 is the equivalent of asking somebody, well, what nationality are you? What religion are you? What race are you? It's no different. Think of it that way. You would never ask somebody that, right? In any setting, it's the same thing. You need to treat everybody the same, regardless of where their lawful source of income is. And I will say there has been a huge amount of undercover testing by outside third parties, not-for-profits, at the state level and at the local level from the government. 3 big lawsuits were filed in the last 3 years by a group called the Housing Rights Initiative, named hundreds of brokers, hundreds of property owners, accusing them of denying access to renters with vouchers. I will tell you, I've heard DOS, and I've seen it in terms of the decisions that come out every month, they will suspend a license for source of income violations. This is one area where there's not a lot of leniency. I also saw that this month, the Division of Human Rights and the governor announced the launch of a new enforcement unit dedicated solely to the resolution of housing discrimination complaints involving Section 8. So there's a huge emphasis on this. New York City Human Rights Commission does a tremendous amount of testing. They have a unit just on lawful source of income. For those of you that haven't taken my legal update class, do you want to guess on how much the department's collected in penalties and fines just on lawful source of income in New York City in the last 5 years? Just on penalties. It's over $2.2 million in damages and penalties. So it's, you may not see it, but there's a lot of testing taking place in this area. So you need to make sure you're training everyone in your office on this issue, especially if they're handling rentals. But even if they're not handling rentals, you may get a call, and they need to know how to handle calls. And so what can source of income discrimination look like? It's a ton of different things. But it's, I don't work with voucher holders. I don't work with landlords who take vouchers. Telling someone that you want to find out if the owner takes vouchers and get back to them. It'd be no different than saying, I need to find out if the owner works with Hispanics, Black, white. It doesn't matter. It's a protected class. The owner must work with them. You can't find anything out. There is nothing to find out. It's putting up any other barriers that may exist. So what do? Simple. Don't turn away prospects because they receive financial assistance. Treat them the same way you would anybody else. Have a standard operating procedure. Does not the one that needs to be on your website for sales, right? And how you treat buyers or potential buyers that come in. But consider having a standard operating procedure for all rental prospects to ensure that everyone's treated the same way. So you're going to ask every prospective tenant the same question and train everyone in your office to say, okay, you're looking for an apartment. Where are you looking? How many bedrooms are you looking for? What's your price range? Not what's your source of income? Not do you have a voucher, right? Again, that's the equivalent of asking somebody, are you disabled? Are you this religion? You treat everybody the same. Show voucher holders the same apartments that you would anybody else, regardless of their source of income, period. Disability discrimination, I'm going to wrap up. I know I don't want to keep everybody too much longer, but it's another tremendous area of testing at the state and local level. And the reason why, it is the #1 form of housing discrimination in this country. The majority, over 53% of all fair housing complaints in this country, reported complaints, stem from disability. And most of them are in the area of rentals. 82% of fair housing complaints in this country stem from rentals. So you put those two together, the bulk of the claims in this country regarding fair housing violations are rental-related disability discrimination claims. And so we've seen a lot of undercover testing here on Long Island and New York City. And these are just a couple headlines. You can see the penalties are severe. This doesn't even include potential licensure issues, because DOS will also come after someone's license for disability discrimination. But you can see the fines, the settlements in these cases can be 5, potentially 6 figures or more. So how can you avoid it? How can everyone in your office avoid disability discrimination? They don't need to be attorneys, but they do need to know and understand the law on a couple basic issues. They need to know that there are required disclosures and notices, and they should be familiar with them. I encourage every licensee to not be in the process of mechanically handing out a piece of paper without knowing what it says and without explaining it. Take the extra few minutes, train people in your office that they should explain forms that they give to a client. It not only protects them, it makes them look more professional. And then give your office the tools to educate your clients. We've created flyers that you can give to sellers, that you give to landlords, that explain what their obligations are under the fair housing laws. Again, it's going to help protect your agents, and it's also going to make them look more knowledgeable. I'm going to end on just a quick primer. these are things that every real estate licensee should at least know. And that is a disabled tenant has the right to request reasonable modifications and reasonable accommodations. And every landlord needs to provide these things. And a reasonable modification is just a reasonable change to a structure that would allow a disabled person to use the premises. So it's a grab bar, a handrail, a ramp, those things a disabled person is allowed to install at a property. And a reasonable accommodation is a change to a policy. So a service animal, a landlord who has a no pet policy, a tenant who's disabled is entitled to a service animal. So New York State felt that it was so important that disabled tenants know that they have these rights, that there is a form that must be given to all prospective tenants at first substantive contact. So that goes along with the agency disclosure and the housing and anti-discrimination disclosure form. And it informs them of their right to request these things. Forms available on our website. I hope everybody who deals with rentals is using it, because it also has to be on a link to it has to be on the broker's website. A lot of brokers don't have a link to this on their website. DOS is starting to issue fines to brokers that don't have a link to this form on their website. And I worry that if it's not on your website, maybe you're not aware of it, and maybe you're not providing it to all prospective tenants, because that's going to result in an even bigger fine and potential license issues. So, you absolutely have to train anyone in your office that's ever dealing with a prospective tenant or that may deal with a prospective tenant, that this is a form they have to provide at first substantive contact. Last thing I just want to mention, because it comes up a lot, the question comes up a lot, is just service and emotional support animals. You need to make sure that your licensees and also that your landlord clients know that they are not pets. That is the simple rule. They are two totally separate and distinct things. Service and emotional support animals, they are not pets. If you remember that point and you train everyone in your office to remember that point, you will very unlikely to have a problem with service and emotional support animals. They are tools to assist someone with a disability. I can't see all of you, but I always say in my class, when I find the people in the screen that have glasses, I say, you have a visual disability. You need those glasses to assist you. I said, the service and emotional support animal are no different. They assist the person with a disability overcome that disability. So think of a service and emotional support animal as someone's glasses. They're walking, barking glasses, and not as a pet. And that's the way, if you remember that and you train your landlords and explain to your landlords that that's the process, there shouldn't be an issue. You're going to treat someone the same way with a service animal that you would somebody who doesn't. So they are allowed to accompany individuals to open houses, to showings. If it's not apparent that the animal is a service animal, you can ask, is the animal required because of a disability? That's really it. You shouldn't really need to ask anymore. You can ask what work or task has the animal been trained to perform, but you take someone at their word, you allow them to view the property, and you move on. You're not asking for medical documentation, the nature or the extent of someone's disability. And just the last points, yes, landlords can have no pet policies. They just can't apply them to service and emotional support animals because they're not pets. Same thing about charging more rent, pet rent. Yes, that's allowed, but you can't apply it to a service and emotional support animal because they're not pets. So that's why I keep saying you get back to that golden rule, service and emotional support animals are not pets. It's really the answer to everything. And if you keep the two separate, there shouldn't be an issue. Finally, check out, we've created a website that we've been updating. We're going to continue to update it. It's called homeforallofus.org. And there's a lot of good information regarding these two protected classes. We kind of understood that they're areas of testing. I think Ethan, thank you, just put it in the chat. It's an area where there is a lot of testing going on, and there's a lot of education to still be done, not only of real estate licensees, but property owners. And so we want you to be able to use these resources to share with property owners, property managers, to assist them in understanding what their obligations are, as well. So that's all I have. I see a question from Jolie, about pet rent or a pet security deposit. I can answer that. So New York State has a requirement that you are not allowed, not you, but landlords cannot, have more than 1 month's rent, for security deposit. So if a landlord has a separate pet deposit in addition to a 1 month security deposit, that would violate the Tenant Protection Act. So what a lot of, I know landlords have done, probably in consultation with their attorney, is they have a pet rent, instead, a monthly rent, $20 a month, whatever it might be, to that way not ask for more than 1 month security. But technically requiring a pet deposit plus 1 month security, would run afoul of the Tenant Protection Act. But again, anything like that, pet rent, pet security deposits of that nature cannot be applied to a service and emotional support animal. They're not pets. I mean, someone with a service and emotional support animal filling out an application for an apartment, they would not and should not indicate that that's a pet. If it's a service and emotional support animal, it's not a pet. So none of those other, requirements, whether it's insurance, anything else would apply. That the tenant would be responsible. I've gotten asked this question too. I know it's not here, but what if the service animal damages something in the apartment, or on a showing, service animal damages something, at the property? The owner would then be responsible. That is just as if the owner damaged the property. So if the owner, walked in and started breaking things, it's no different than if a service animal, were to break something. The owner would be responsible for that damage. I don't see any other questions in the chat. Ethan or Marianne, was there anything else in the Q&A that came up? I didn't have that open. I apologize.
Roy asked what was the logic to the decision. I'm not exactly, there was a little bit ago, so I'm not exactly sure which he was talking about there. If he wants to clarify in there.
Could have been, I maybe he was talking about the verdict in the class action lawsuits. If he was, there was no real logic to it. Yeah, he says yes. You could read articles on it. I mean, the jury didn't have to give any logic. It was a jury trial, so it wasn't a written opinion. The jury just renders its verdict. It did come back very quickly. Presumably they just found the plaintiffs satisfied their burden, and potentially that their witnesses, were more credible. That certainly you never know with a jury. So, in this case, this jury in Missouri found in favor of the plaintiffs. A jury somewhere else could find totally different. But there's no, written decision from the jury. They just found that it was, an antitrust violation. Some of I would say the way the verdict was rendered could have been based on some limitations that were, imposed by the judge, and instructions that were given to the jury that were kind of, from a legal perspective, argued back and forth. And I think that's going to be the nature of the appeal. I think hopefully an appellate court's going to see this differently when, it looks at those legal issues and makes a different determination. And I know that's what NAR is hoping for. Roy asks, where can we find that a tenant does not have to put their service animal on an application? Well, it's again, a service animal is not a pet, so they should not have to identify that. And to me, it would potentially be a fair housing violation if a landlord's asking somebody to identify a service animal. That's basically asking the tenant, are you disabled? Are you this race? Are you? It's a major potential violation by the landlord in that case. Again, service animals, emotional support animals must be allowed. They are not pets. All right. I don't see anything else. Did you see anything else, Ethan?
No, I think we covered it all.
I thank you, everybody. Again, we will put the slides out. We'll send them out to everybody that attended. And certainly if you have any questions, or need any more information beyond what was in there, please let me know. When will you be receiving the slides? That's one more question. I don't know. It'll be shortly after the presentation. I'll make sure you have them. I'll send them out to Ethan and we'll get them out to all the attendees.
Yeah, I'll try to send them out.
Okay.
In just a little bit after this, since we don't have a ton of people here, I can email them all over to everyone. So
All right, great. All right. Thank you, everybody. I really appreciate it. Hope everybody has a great rest of your day.